Right. Julius Malema and Mbuyiseni Ndlozi are back in court today. They're facing charges of assaulting a police officer at the funeral of Winnie Madikizela-Mandela in 2018. Colonel Johan Venter is currently on the stand being grilled on video footage showing the incident. I'm now joined by legal expert Ulrich Roux. Ulrich, so the defense this morning painstakingly took Lieutenant Colonel Johannes Venter through that CCTV footage frame by frame to poke holes in his account of what happened. How important is that to their defense strategy?
Hi, good afternoon, Andy. Well, what I've seen of the video footage, it is clear that there was an incident or a scuffle between the two accused and the witness who was on the stand this morning. But I can only imagine that the strategy being imposed by the defense team is that the witness provoked the assault. So in other words, he first acted in a way which justified Mr. Malema and his co-accused to push him away and to get him out of the way, and that he should never have refused them access to the funeral. It is a old and trite law in South Africa that provocation is not a defense to assault. So one would have to wait and see where the strategy is going. Lawrence Otis, the advocate acting on behalf of the accused, is certainly very experienced and an excellent defense advocate. So I'm sure that his strategy is to try and show to the court that had the witness not acted in an obstructive manner towards the two accused, then it would not have been necessary to push him out of the way. But we'll have to wait and see how that progresses today.
So that issue of provocation is proving to be rather an emotional point for both supporters and both Julius Malema and Mbuyiseni Ndlozi, claiming that they should never have been denied access, especially the nature of this funeral, Winnie Madikizela having been a mother figure to Julius Malema, him viewing her as a mother. However, it's interesting that you mention provocation not being generally used as a defense in assault cases. Has there been any history of that proving a successful defense?
Well, it all depends on the degree of provocation. So obviously, the reasonable person test must be applied. If a person provokes another person and possibly places their life or their safety in danger, then certainly if you take action in order to avoid your safety being compromised, then it is justified. But the only real defense to an assault like this is if you acted in self-defense. So they will have to prove that the obstruction caused by Mr. Venter, the policeman, justified them pushing him out of the way in order for them to gain access to the funeral. It's unfortunate, in my opinion, that this is being swept up in such an emotional way, and that it has become somewhat of a race issue now again. The policeman's version is that in his he was under the impression that they did not have access to gain access to that funeral, whereas they say they did. So I don't see any race issues coming into this. It was purely an incident of a policeman doing what he thought was his job at the time, and then obviously the two accused thinking that they were allowed to access to that funeral, and that if they were being prevented from attending the funeral, then they had to take the action that they did to enforce their rights to attend that funeral. So that is what it is, and the court will have to look at the objective evidence being led, and that's going to come down to whether Julius Malema's actions of pushing the policeman out of the way were justified, and whether his obstruction to prevent them from gaining access to the funeral was also justified, and weigh those two rights up against each other. And remember that the state will have to prove their case beyond a reasonable doubt. So they will have to prove beyond a reasonable doubt that it was an unjustified and unlawful assault on the policeman, whereas the two accused will only have to prove that their version is reasonably and possibly true, and that is obviously that we had to act in the way that we did in order to enforce our rights to attend that funeral, and the magistrate had to weigh that up.
Apologies for interrupting you there. Before I let you go, I want to ask as well, another question raised by this case is that whether the seriousness of the alleged assault also comes into question. So here's a question for you. Had the police officer who was allegedly or pushed, been a woman, do you think that this case would have been viewed differently by both the public and the legal system?
So the only place where the severity of the assault really comes into play is if a person is convicted, and then that would contribute towards the sentence being handed down. So obviously, if a person is assaulted in such a brutal or vicious way that he suffers long-term and serious injuries, then a punishment could be handed down, could be harsher than if the case was that it was merely a bruise suffered or much lighter injuries. But the fact is that the court must look at is whether there was an assault or not, and that's the beginning point. And the severity of the assault, or whether it was man on man, man on woman, or other way around, will only come into play really if there is a conviction and when sentencing is handed down.
All right, thank you very much for that update. Legal expert Ulrich Roux speaking to us there.